return of bond. Now, this was a situation that was raised as an example in a training course in the last week, so by an agent. And it was about an agent who had, their agency had experienced that a bond had been returned to a tenant. So the agent had been out, inspected the property, said fine, returned the bond to the tenant, and then the landlord had gone in after that, done an inspection and said, well, what about X, Y, and Z? Saying, look, that it wasn't like that at the beginning, and said you should not have returned the bond, you should be making a claim on that. Now, this can go two ways. Sometimes it is a landlord being unreasonable, and we have to start looking at the issues of fair wear and tear. And, there are some landlords who want flooring replaced because, it was defective in the first place and they want the tenant to pay for new, better standard flooring. Heard that story a couple of days ago. But, this was one where they actually had photos, and many of you as agents take photos through your routines, through your ingoings, your outgoings. And so there were photos there that were clear that the property was not in that condition. But the agency had returned the bond to the tenant. So where do they stand? They could try and get it back. Good luck. So that's going to become a tribunal matter. So you're going to be asking your landlord to pay to attend tribunal, although I'd suggest you probably wouldn't ask for that. And you'd be wasting a whole lot of time going down that, any of those points. So, it's an interesting process here. So, what you need to remember is we go back to what we always talk about, and it's the communication aspect. You need to communicate. Yes, you need to be thorough in your inspections, noting what is the difference between when they went in. So have a good ingoing inspection report. Obviously have some good routine inspection reports throughout the term of the tenancy. And then your outgoing inspection report needs to show those differences between start and finish. Again, this can be shown by the photos, and it can be shown from the actual written reports. And your communication to your landlord actually saying, we are going in to do the final inspection. Obviously, you're welcome to come if you're available. This is when we're doing it. The same way you would invite your tenant, or should invite your tenant, to say that we're doing the outgoing inspection report at 10 a.m. on Tuesday the 15th at whatever time or whatever date. And please, you are welcome to join us at that outgoing inspection report. Odds on they probably won't if they're not available, or they may, if they really want to be there, they'll try and negotiate with you for a different time. And that's obviously giving you a little bit of a heads up on their reaction to being invited as to whether they're going to make a claim different from what you think you're going to be making a claim for. So again, it's about that communication between you, your tenant, and most particularly to your landlord. So what was the outcome of this particular scenario? The landlord obviously rang the licensee in charge and owner of that agency, and who paid for the difference between the work being done and not being claimed back from the tenant? The licensee in charge. So the agency actually paid for that. So hopefully they've got some different processes within their agency now about their communication methods. So it's not so much a legislative requirement. They'd done all the right things. They'd done their final inspection. They'd talked to the tenant. They'd released the bond. Everything had been done in the legislative way, but the communication hadn't been there. Therefore, it ruined the actual process and the deal, and the agency ended up paying for that. So yeah, interesting process there. So guys, yes, it's about complying with what the legislation is telling you to do. It's also making sure that your communication is spot on.